welcome to this FedSoc Forum webinar call. Today, April 29th, 2024, we're delighted to host a Courthouse Steps oral argument on Starbucks Corporation versus McKinney, which was argued last week before the court. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the expert on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I'll keep my introduction for our guest today brief. But if you'd like to know more about our speaker, you can access his impressive full bio at fedsoc.org. Today, we are fortunate to have with us Sheng Li, who is litigation counsel for the New Civil Liberties Alliance. Prior to joining NCLA, Mr. Li served as counselor to the Administrator of Wage and Hour at the U.S. Department of Labor, and he's also worked in the private sector as a litigation associate at Patterson, Belknap, Weber, and Tyler, as well as at Kirkland & Ellis. Mr. Li is a graduate of Johns Hopkins University and Yale Law School, where he was the managing editor of the Yale Journal on International Law. And after graduating law school, he served as a law clerk to the Honorable Danny Boggs in the U.S. Court of Appeals for the Sixth Circuit. And I will leave it there. A last note, and then we'll turn it over for a time of opening remarks. If you have questions throughout the program, please submit them via the question and answer feature, as we'll have an extended portion of today's webinar where we'll be able to address those. With that, however, Mr. Li, the floor is yours.
Thanks for having me to discuss this case. Quite an interesting case, Starbucks v. McKinney. McKinney being the regional director of the National Labor Relations Board in the Tennessee area and surrounding areas. Even though this was an NLRB case, it's not really a labor case per se, but rather an administrative law case concerning the board's power to obtain an injunction under Section 10J of the National Labor Relations Act. That section allows the board to get an injunction against the target of one of its enforcement actions, be that an employer or a union, although it's in recent years it's been used exclusively against employers, and it can get an injunction when doing so is just and proper. And the question presented is, what does that really mean? What are the standards for that injunction that the court decided? So maybe a little table setting on the kind of legal backdrop and the factual backdrop, and then we can jump into what happened at oral argument last Tuesday. So the question again was, what must the NLRB show to get an injunction that is just and proper? And there's a circuit split on this question. Four courts of appeal, and those are the Fourth, Seventh, Eighth, and Ninth circuits apply the traditional four-factor injunction test that comes out of the Winter case out of 2008. And those four factors are: first, the entity seeking the injunction must show a likelihood of success on the merits. Second, it must show that with absent an injunction, it is likely to suffer irreparable harm. Third, the balance of equities must favor an injunction. And fourth, the injunction should favor the public interest. And I think most of our listeners are familiar with that tried and true injunction standard. However, five courts of appeal apply a different test when the NLRB is the agency seeking it. And this is actually a less rigorous two-factor test. The first is there reasonable cause for NLRB to seek an injunction? Meaning, does the NLRB kind of allege factual evidence and make legal arguments that are not frivolous and not insubstantial? So this is a lot less, just looking at it, than the likelihood of success standard that we just talked about. So that's one difference. And second is they have to show, the NLRB has to show that the injunction would serve the NLRB's remedial powers, which is quite different from those other kind of balance of equities and irreparable harm factors that normally apply. And just a word on this not frivolous standard. This is the first on the part of the reasonable cause test. It's quite deferential to the NLRB. Obviously, the NLRB courts have kind of bent over backwards in the past in those other circuits in Third, Fifth, Sixth, 10th, and 11th circuits to grant injunctions based on kind of legal and factual arguments that may differ from how the courts themselves would have thought about it, but they instead just deferred to the NLRB's position. So with those, those are the two standards that for NLRB injunctions that courts have used. I will mention as an aside, the First and the Second Circuit uses sort of a hybrid standard, but those are the two kind of main branches, and that's the circuit split on which the court granted review. And as for a little factual background here, the case in the Sixth Circuit is one of the cases that uses the kind of the easier standard. And what happened was back in 2022, there was a unionization effort among Starbucks stores, and I think that unionization effort is still ongoing. And particularly in the Memphis store, a number of Starbucks employees opened the store after hours and let in a film crew to make a pro-union film without the authorization of the store manager and against corporate policy. So that because this violated Starbucks policy, Starbucks has then terminated 7 of these employees. I think there were 8 involved, but one of them was not terminated. Later in 2022, the Memphis store did vote to unionize, and that union filed an NLRB complaint, which, among other things, sought the reinstatement of the 7 employees who were terminated. NLRB then started an administrative enforcement action against Starbucks, alleging that the terminations violated labor law because it was retaliation of and it discourages protected unionization activity. That administrative proceeding is still pending before the NLRB as of today. It's internal to the agency, but while that was pending, the NLRB then also sought under Section 10J of the Act in Tennessee District Court an injunction requiring Starbucks to rehire those employees while the board was deciding and considering the administrative proceeding. The district court in Memphis granted that injunction, so required Starbucks to rehire those employees, and it consistent with that circuit split I talked about earlier, applied the more relaxed standard for an injunction. So it deferred to NLRB's factual allegations that the terminations were in retaliation of unionization activities, and as opposed to being consistent with Starbucks's general policy of not letting employees in after hours to do unauthorized activities. And in fact, the district court, quote unquote, disregarded in its opinion the Starbucks the facts that Starbucks offered refuting NLRB's account of why these terminations fired and how they were fired. Instead, it said, because of this deferential, more relaxed two-part test, conflicts in evidence and issues of witness credibility are really left to the NLRB under the Sixth Circuit's rule on this matter. And as to that second part of the two-factor test, the district court said an injunction was necessary to return the parties to their status quo ante, and therefore granted the injunction, which again is kind of different and more relaxed than the typical irreparable harm standard that litigators typically have to meet to get an injunction. On appeal, the Sixth Circuit affirmed the injunction based on this relaxed two-factor test. And it was a unanimous decision on that matter, but Judge Riedler did reluctantly concur. He said, hey, based on our Sixth Circuit precedent, yes, we do apply this relaxed standard where all NLRB has to prove is make a non-frivolous argument at this stage, and we have to grant an injunction. But he said this relaxed standard seems to be inconsistent with what the Supreme Court has said applies, typically in injunctions, which is that four-factor test from Winters, and that while Congress may be able to depart from that four-factor test, the phrase just and proper was not clear enough of a statement to do so. And so I think Judge Riedler's concurrence there was, almost a semi-dissent, and really teed up the circuit split and teed up the cert petition that Starbucks filed, and Starbucks did file that, and the court agreed to review, and then we had oral arguments last week. So with that backdrop in mind, we can come to last week's oral argument. Lisa Blatt, a veteran litigator, I think she holds the record for the most number of Supreme Court cases by a woman, argued for Starbucks, and Austin Rayner argued for the board. Now, normally, I think it's risky to predict outcomes based on what was said during oral argument, but as we discuss in more detail, based on kind of the stridency of some of the justices' questioning and some of the concessions that NLRB's attorney, Mr. Rayner, made, I think it's pretty safe to say, while the exact opinion we can't predict, it's pretty safe to say Starbucks is very likely to come out on top here. And why is that? Well, to start, NLRB's briefing in this case surprisingly took a step back from the position it took in the lower courts. Again, the lower courts, Starbucks argued, hey, you should apply the traditional 4-factor test. NLRB in the district court, the Sixth Circuit, argued instead for the more relaxed 2-factor test under Section 10J. But instead of standing really behind the 2-factor test, NLRB's position kind of transformed at the cert stage. It said, hey, we understand this 4-factor test exists. This 2-factor test is merely, it's not really that different. It's what it's merely kind of a reflection of the 4 factors. It incorporates them, and it's just applying that. It's not in the NRA statutory context, and therefore no reason to grant cert on this, Your Honors. Please, nothing to see here. The court clearly didn't agree and did in fact grant cert, and at the merit stage, NLRB's argument was much the same, making the argument that the 2-factor test was not so different from the 4-factor test. So that's already, coming into the oral argument, I think a substantial concession there. So coming in, the question presented and question that everyone's trying to answer at the oral argument was really, well, is it true? Does the NLRB preferred 2-factor test, does that depart from the traditional 4-factor test? And if so, is that departure justified by the statute? And right off the bat, I think it seemed pretty clear that the justices, or at least many of the justices, were not satisfied with the NLRB's 2-factor standard. There are questions all presumed that the 4-factor standard applies, and the real question, at issue was whether the 2-factor standard was somehow an adequate reflection or adequate substitute for the 4-factor test. And the questioning really focused on that first factor in the standard 4-factor test, the likelihood of success on the merits. Under the traditional test, you have to show that, hey, there's a little merits peaking. Before we grant you preliminary relief, the court's going to make sure that based on the preliminary legal arguments and factual evidence presented, that you have you're more likely than not to prevail. But under NLRB's preferred standard, that's not quite true. All it has to do is show a not frivolous set of facts and not frivolous legal argument. And not frivolous is the quote unquote the language that the courts below have adopted when applying that test. So it's quite a big difference, when you look at it. And so the court, I think, focused on that difference because it's quite egregious and quite large between likelihood of success and not frivolous. Not frivolous, I don't know where the analog is, but it's got to come pretty close to a Rule 11 sanctionable argument, and I just think it just can't be that an agency can get an injunction as long as its arguments are somehow past the sanctioning, Rule 11 test. I think the arguments, many of the questions focused on whether this ultimately comes down to a kind of a super level of deference, and this case is argued in a way under the shadow of the Chevron cases, Relentless and Loper Bright, which are reconsidering the Chevron deference, and in many ways the deferential standard review for this injunction test is in many ways a stronger version of Chevron, because at least under Chevron, judicial deference to an agency's interpretation of the law is based on the agency's final action. After the agency does notice and comment and considers all the facts and does a full fact-finding and legal analysis. But here it's at the preliminary stage. It's just the agency's initial litigation position. So in many ways, the NLRB is just asking for judicial deference to its legal arguments and factual findings for the purpose of litigation, and that's like, I think, a whole level of deference that's far stronger than Chevron. And if the court's reconsidering Chevron, it's not likely to grant deference that's much stronger than that. So early in the argument, even we can see that the justices being kind of very skeptical to the NLRB's test, even as she pushed back on Starbucks positions with respect to some of the. This is Justice Sotomayor was pushing back on the Starbucks position on irreparable harm, balance of the equities, public interest. But even as she did that, I think she clearly on the likelihood of success on the merits didn't think the NLRB's not frivolous standard satisfied that, saying look, so I'm just going to find this. She actually commented, I do understand why that's the likelihood of success on the merits issue. That needs to be corrected because Lisa Blatt, you're right. It's the court that has to decide the likelihood of success on the merits, right? Not the agency. The court has to exercise some kind of independent judgment on this point. And on this point, the most of the other justices agreed with Justice Sotomayor's position there, which they made clear in their intense questioning of the NLRB's attorney later on. And these questions led to some concessions, and we can just start. Again, Mr. Rayner conceded at the beginning of his argument that all four of the traditional factors are relevant here, which was, again, not what NLRB has argued below, nor what the lower courts did. So that, to start, I think, concedes that the lower court may have gotten it wrong and provides a basis for reversing and remanding. And again, the justice focusing on the likelihood of success factor kept on pressing on the amount of delta, the amount of difference between the traditional test on likelihood of success and the likelihood of success standard on the NLRB standard. Justice Gorsuch, looking at just the fact-finding aspect of that likelihood of success, said, so the Sixth Circuit rule, talking about the Sixth Circuit rule, that you can't engage in fact-finding, that has to be wrong, right? That he asked the NLRB attorney, and after some hemming and hawing and back and forth, he pressed it and said, hey, Justice Gorsuch, that statement is wrong, right? Mr. Rayner, that statement on its own is. So again, a concession by NLRB that the lower court's refusal to do any fact-finding, refusal to consider countervailing factual evidence that Starbucks presented below was an error. And that concession itself, I think, already creates a basis for reversal. Justice Kavanaugh at this point jumps in and says, well, do we apply the test the same way we usually apply it as a general matter? And otherwise, he's looking for the delta, the difference between the normal test and the NLRB's preferred test. And Mr. Rayner's, I think, answer to that question was also a decisive concession here. He responded, I think there has to be some translation on the context, and on just focusing on likelihood of success for a moment, we think that there has to be a substantial legal theory and there has to be sufficient facts a reasonable fact finder could find for the board. And at that point, both Justice Kavanaugh and Justice Gorsuch kind of jumped in and said that doesn't sound like likelihood of success on the merits at all. So again, it's very different. You have to find under the traditional test, more likely than not that you're going to succeed on the merits, whereas under the NLRB's test, it just has to be a substantial legal theory. I'm not sure what really that means. Maybe a reasonable fact finder could find it. And after some back and forth, everyone kind of agreed what the NLRB was doing was getting injunctions based on less than a 50% showing, which is, again, that's I think a major difference here. NLRB made some arguments to support its sort of its claim for a more deferential test based on there was a statistical argument that was presented. Its arguments like, well, we have 20,000 complaints filed every year, and we only seek a few dozen 10J injunctions. Therefore, these 10J injunctions must be really important and must be really meritorious. Because we're being so selective, was the NLRB's position, and the justice didn't seem to buy that. Justice Roberts says, well, your selectivity here, could that just, could the inference be opposite? Was what he asked, because it shows that you're putting your resources on these cases because you think they're harder cases to win. So that's why you're being selective. Justice Alito presented a hypothetical of, well, to NLRB's attorney who was from the Solicitor General's office, and he asked, well, the Solicitor General gets a lot of requests for cert petitions for making oral arguments, and obviously it's selective in deciding which cases it seeks cert on, which cases it seeks emergency relief on. Should the Solicitor General's selectivity be a factor for the courts on the decision on the merits? Can the Solicitor General say, hey, we only bring up a few cases each year to the court, and therefore these cases are meritorious, and the NLRB attorney said maybe that could be a consideration, and Alito responded seriously, in an incredulous way, suggesting quite the selectivity of an agency or of a government actor in bringing cases should not be a consideration for courts when deciding the merit, whether those cases present meritorious arguments. And ultimately, the NLRB's argument for a relaxed review comes back to what they say is the statutory context, which relies a lot on legislative history of what Congress intended, even though the phrase just and proper may not give much evidence to that intent. Again, Justices Thomas and Gorsuch both came back at this and said, well, if we're going to give this much deferential review to an agency's litigation position based on just and proper, shouldn't all these other agencies, these alphabet soup of agencies, the SEC, FTC, CFTC, et cetera, shouldn't, that they all have authority to seek injunctions in district court pending an administrative adjudication? Wouldn't the NLRB's position be also that these hodgepodge of agencies get differential treatment, and whether that's an appropriate outcome? I think they're very hesitant to accept any argument that would broaden this sort of deferential treatment of all kinds of agencies. Among the justices, I think Justice Jackson was the only one who, said a word of support for the NLRB standard on the likelihood of success prong. Justice Sotomayor had some support on, irreparable harm and others, but on likelihood of success, I think Justice Jackson was really the only one. She asked, is this is a different context from other PIs? To the extent, she says, to the extent we're applying the 4-factor test, it's the likelihood that the board is going to decide that there's an unfair labor practice in this situation and reverse the stakes on the ground or whatever. Isn't that right? So again, she thinks based on the statutory context, her interpretation seems to be that what the district court should be doing is not necessarily deciding the issues on its own, but rather what the district should be doing is trying to predict what the NLRB is likely to do in the end, because the NLRB was given the task of deciding these issues. However, I think Justice Kagan came in right after that and shut that argument down, saying, I don't see how that could possibly be. And a court is supposed to say, well, I have one view of the law, and I'm just going to assume that the board has a board is not supposed to say that I have one view of the law, and I'm just supposed to assume the board has a different view of the law. And at the end, Justice Kagan put it rhetorically, I think sums up the argument. It's got to be the court's view of the law, right? And if it is to be the court's view of the law, it can't be a non-frivolous standard. And so at least on that likelihood of success prong, Starbucks is very likely to win this case. The justice asked both sides whether there could be a short opinion, and I think it could be based on the concessions that NLRB made. So the decision would likely focus on that likelihood of success, because that's what occupied most of the argument. Maybe there was some discussion on irreparable harm as well, and what the board has to show when it seeks an injunction for irreparable harm. Everyone agreed that chilling union activity could be irreparable harm, but Starbucks and Lisa Blatt argue that such chilling has to be tied to some sort of discernible, irreversible discrete activity, such as a vote for a union, for unionization, and that wasn't the case in this case because the unionization vote had already occurred. And with that, I guess looking at predictions, I normally hesitate to make any predictions about outcomes of cases, but here I think Starbucks is highly unlikely to win. The court is highly unlikely to say that the four-factor test applies, and that at least with respect to the likelihood of success prong, that the test that's used in the Sixth Circuit and a few other circuits around the country doesn't pass muster. And with that, I think we can open it up to some questions.
Sounds great. Thank you so much for that summary of the case and the facts associated with it, as well as oral argument. We do actually already have a question from our audience, and so I'll issue the brief reminder here to the rest of our audience. If you want to submit a question, the Q&A feature at the bottom of the Zoom screen is the way to do that. John Scheller from the audience asks, the NLRB, like any litigant, could presumably seek relief under Rule 65 without invoking 10J. Why would the NLRB be restricted solely to Rule 65 when it has this extra authority under 10J?
Well, I don't know if it does have Rule 65 authority. That's actually not been used. So if 10J didn't exist, it wouldn't normally be able to get into federal court. And in fact, this was part of the legislative history here. It's in the 1930s. The National Labor Relations Act was passed to, in part, to get courts out of the labor, getting labor disputes and giving the power to NLRB to decide them. And at that time, the rationale was folks thought the courts were putting a lot more injunctions against labor unions. The courts were too employer friendly, and they wanted, the Congress wanted the NLRB to be the final decision. It was only in 1947 that the statute was amended to provide for 10J injunctions, allowing the board to seek an injunction while its investigation and enforcement action was pending. So I don't know if so based on that, I don't think prior to 10J being added in 47, NLRB was actually not able to get district court injunctions.
Got it. Thank you. That's a helpful answer. You mentioned a little bit in your discussion the nature of the NLRB and the way that its structure is, and the fact that this is before there's been a final decision by the board. Part of the conversation during oral argument was on whether or not the specific nature of 10J and the way that the NLRB has a prosecutorial arm versus a deciding arm, how that affects whether or not there should be deference here. Can you give a little more background to that conversation and whether or not the decision here could affect other agencies and whether or not they apply for these sorts of injunctions?
Yeah, so just on the first part, NRB's general counsel is the one that brings cases. And before seeking a 10J injunction, NRB's general counsel typically, I think actually through NLRB regulation, has to present the case to the board, the 5-member board, and the board has to sign off on that 10J injunction. One of the NLRB's arguments is we're very selective in doing that. The board doesn't sign off on just any of these injunctions. So once the board signs off on that injunction, then the general counsel and the regional administrator in charge of the enforcement action could then seek it in district court. So that's how it happens internally to NLRB. And I'm sorry, could you say the second part of that question again? Whether it affects agencies?
It was how it would affect other agencies. There was back and forth as to what the impact of this could be.
Right. So the deferential test that the NLRB sought, NLRB's argument was, one, we're very selective, and two, this furthers our remedial purpose of remedying labor violations. But a couple of the justices, Thomas and Gorsuch in particular, were skeptical of that, in part because the same argument would apply to virtually any agency tasked with regulating companies and enforcing and adjudicating cases against regulated entities. So the SEC, FTC, and so forth. Those agencies do have the power to seek injunction in district court, but they have all been required to do so based on the traditional kind of more strict 4-factor test. And the justices were concerned, well, if we rule for NLRB here, does that open the door for SEC, FTC, and so forth to get injunctions against targets of enforcement adjudications in district court under a far more relaxed standard? And one difference here, I didn't mention, and the oral argument didn't dwell on this, but one issue here is that in a typical injunction, the court is in charge of really how long that lasts, because you're litigating a case before the district court, and so the district court can make sure it doesn't last longer than it needs to be. Here, the injunction lasts until the NLRB finishes its adjudication. So actually, it's the party that's seeking the injunction has full control over the length of the injunction, which I think may play a little bit in deciding how fair it is to offer a deferential standard.
Got it. Thank you. That's helpful. Next audience question gets to what was at issue here. Was this on the actions of the former Starbucks employees? Was that being litigated, or was it focusing solely on the standard of review for this kind of injunction?
Yeah, it was solely on the standard review. So there's no decision on whether the Starbucks employees, actually violated Starbucks policy, whether they were, they were definitely terminated, but then the question is whether they were terminated for a violation of Starbucks policy or if they were terminated for unionizing. So if they were terminated for unionizing, that, could be a violation of labor law. So that's the issue that's before the NLRB right now. And NLRB has sought an injunction saying, well, before we actually make a final decision on whether Starbucks termination was lawful or unlawful, we want to force Starbucks to rehire the 7 terminated employees and keep them on the payroll for this period of time. And I would say Starbucks has been targeted with about a dozen of these 10J injunctions over the last couple of years. So I think this might be them saying, we're sick of it and we're gonna take it all the way to the Supreme Court. So to answer the question, the underlying legality of Starbucks action has not been decided, and we're just dealing with what the legal standard is for reviewing when NLRB seeks injunction. So if, as I predicted would, if Starbucks were to win, this case would probably get sent back and ask, did apply the correct standard? Does NLRB have, make the case under the correct standard?
Got it. Thank you. Next audience question, I will try to read verbatim, and hopefully it will make sense that way. Doug Seaton asks, the NLRB's GC seems to threaten to seek a 10-J injunction in discussions when the employer is the charged party, and it does so, seemingly to press for a concessionary settlement. Excuse me. This almost seems to be a policy. Comments on that?
Yeah, so that's a great question and a great point. So when the NLRB goes after an employer, again, if these injunctions are granted at a lower standard, the NLRB is able to, what the NLRB seeks in ultimate relief when it goes after an employer in an enforcement action, it's also very often very similar to what they seek when in a 10-J injunction. For example, here, in the NLRB, when in the underlying dispute, NLRB is trying to seek various relief against Starbucks, including the reinstatement of the employees, which they have to normally prove in a normal case, which is reviewable by courts of appeal. But if instead they can get one of these injunctions under a deferential standard, why bother proving it, in normal case if they can just, by making non-frivolous allegations, get an injunction and get the exact relief that they want. And then the employer is hit with this exact relief and then put into, a pretty bad negotiating position. Why? Because then Starbucks can drag out not Starbucks. NLRB can then drag out the proceeding, and Starbucks has to hire these employees and maintain them on payroll until the very end. Now, hiring seven employees is not a big deal for Starbucks, but some of the relief that NLRB has been able to obtain has been quite onerous, including forcing, in a Third Circuit case, forcing the employer to not sell $1 million factory that was operating at a loss. So if you're the employer in that case and you get one of these injunctions hit on you, and you're like, well, that's going to cost me a ton of money, so I better settle this thing quickly with NLRB, because once they get the injunction, they have all the power. They can just sit on this case for years and years and years, and I'm losing money hand over fist every month. So I'm going to settle this case on unfavorable terms. And if you step back from that, if the NLRB doesn't even have to get the injunction, because if the standard for getting an injunction is very low, as it is in the Sixth Circuit and a few other circuits, NLRB can just threaten to seek an injunction. And that very threat, if you're the employer and you read the precedent and say, oh, well, they can get one if they want, it's a very low standard, and once they get it, it's cost me a ton of money, maybe more money than it's worth to defend this enforcement action. So my best bet is just to settle the case. And that tactic, my understanding is, even though NLRB formally seeks relatively few of these injunctions, they threaten to seek many more. And that tactic, pressures employers to settle on unfavorable terms. One maybe beneficial outcome to this case would be to take away that coercive negotiating tactic from the NLRB's toolbox and force them to actually prove labor violations.
I'd love to follow up on this, and this touches a little bit on something you mentioned during your overview. There was some back and forth during the oral argument on the statistics surrounding both the rate at which the NLRB applies for these and the rate at which they win either in front of themselves or upon appeal. How relevant were those factual disagreements to the legal arguments being made, and what effect could that have on the eventual decision?
Yeah, I don't think they were particularly relevant to the discussions here. Obviously, NLRB, on the first part, on how often they seek these injunctions, obviously NLRB wants to make the point that because they seek relatively few injunctions, I think a couple dozen a year, I don't quote me on the stats, out of the thousands and thousands of complaints they get, that they're making, well, these must be selective and meritorious. But again, that's not necessarily true, because as the questioner, as the previous question suggested, they could just threaten to seek these and get a lot of mileage out of the lower standard. On how often NLRB succeeds ultimately on the merits, again, I don't think that really it's that revealing of anything, because so many of these cases will just settle. And so, yes, it's true that NLRB doesn't succeed on all of its, when it gets challenged, it doesn't succeed all the time before the board. But the cases that actually make it to a final board decision, let alone the cases that make it to, I guess, the eventual petition for review in federal appellate court, represents a very small fraction of NLRB enforcement actions. And again, because most employers will fold and settle for economic and business reasons, it typically is only the cases that do get decided, ultimately do see the light of day in a federal court, are going to be the closer cases where the employer either thinks it really should win, it's been treated really unfairly, or a case, potentially like this in Starbucks, where Starbucks has been hit with, one of these injunctions after another over the past few years. And even though each single injunction might not be enough for Starbucks to say, let's take this all the way up, the fact that they don't want, they're repeat players in this game, so they have an interest in changing the rules so it's more equally applied. So to answer that question at least more directly, yeah, it's very hard to base it on the statistics, and I think the justices, to the extent any of them commented on NLRB statistical argument, they both they tended to be skeptical of that the statistics prove anything.
Got it. Thank you. Next audience question asks, why now? This splits existed for a while.
I was quite surprised. When NCLA learned about this case, we filed an amicus brief in support of Starbucks, of course, but when we learned about it was quite shocking at how much and how egregious the deference was. And I'd ask myself, like, wow, how could this persist for so long? And I think there's a couple, couple potential explanations. One is the composition of the court, the Roberts courts, has been, at least in recent years, or especially in recent years, skeptical of agency action. We see that, this term with the reevaluation of the Chevron doctrine, certainly. So this case kind of falls within that pattern of skepticism towards agency power. The second is actually, well, this two-factor test, this deferential test, was developed decades and decades ago when the preliminary injunction standard was not so strict or uniformly strict. It was the Winter case in 2008 that really set it. And while courts used the four-factor test prior to that, they did it in kind of a more loosey-goosey way. They balance it, say, well, you don't need to show as much likelihood of success on the merits if there's a lot of balance of the equities, or so that you didn't need, it wasn't those factors weren't hard and fast, weren't very strict before Winter. And so under that kind of more malleable four-factor test, maybe the NLRB's preferred test may not depart from that so much, but I think once Winter came out, the difference between the four-factor test and the two-factor test became indefensible.
Got it. Thanks. Were there any arguments you were surprised to see come up at oral argument? And conversely, was there anything you were surprised not to see raised?
We were surprised. I guess we were surprised when the government's brief came in and they, implicitly conceded some points of conceding basically that the four-factor test is the four factors are relevant, and kind of hinting that that's the correct test. I mean, I don't know why they did that, because that's not what they argued below, but maybe just because they see the composition of the court and think that if they were to argue that just a full-throated defense of an explicitly deferential two-factor test would not get them very far. But as we saw in oral argument, the justice kind of teased that out, and kind of the questions made clear that that NLRB doesn't really believe the two-factor test is somehow just a mirror image, a reformulation of the traditional four-factor test. As for kind of surprising arguments, I think I think Justice Sotomayor it was that mentioned at the end there might be a mootness issue here, because it's possible that the NLRB actually renders its final decision before the court renders its final decision against Starbucks, yay or nay, before the court has a chance to put out its opinion here. I mean, that's kind of theoretically interesting. I don't think it's going to happen because we're in April and the court's going to make its decision in the next couple of months. So I think it's unlikely that that NLRB is going to somehow preempt the Supreme Court by getting a decision out tomorrow or something like that when this case has been before them for several years. And even if that happens, this obviously wasn't briefed and I haven't really taken a look at it, but I'm skeptical of a mootness argument, even if that were to happen, because, as I mentioned, Starbucks has been hit with multiple of these 10J injunctions over the last couple of years. So this seems to me like a, repetitious yet evading review situation.
Got it. Thanks. Well, I know we're winding down. So the last couple questions on potential ramifications of this case. Seems that there may be a way that the court is leaning. So I'll start with that hypothetical first. What is the implication of this case if the court rules against the NLRB?
I think I think the NLRB will just be, one reason why we think the court is likely to do that is because it's actually, I think, a narrow decision. It doesn't change the facts on the ground very much. NLRB in those circuits that apply the deferential test will just have to do what's already been doing for decades in the circuits that apply the traditional four-factor test. So that creates consistency across the board among courts of appeals, and I think that's ultimately a good result. Plus, from just kind of a fundamental fairness due process perspective, it puts the NLRB kind of on an even playing field with employers that it goes after. So it doesn't have the ability to use the threat of a easy to obtain 10J injunction to force employers to cave and settle on unfavorable terms. I think ultimately it's good for due process. These 10J injunctions deprive employers of property rights if you're forced to retain employees that are otherwise unwanted, if you're forced to not sell a property that you own, etc. And you can't deprive anyone of property rights without due process of law, and certainly meeting a non-frivolous standard doesn't supply due process of law.
Got it. I'll ask the reverse question. What are the implications of this case if the court rules in favor of the NLRB?
Yeah, and that would be, I think, I think it's highly unlikely because of how momentous that would mean. And Justice Thomas and Gorsuch both, considered this and said, if we rule for you, NLRB, doesn't this mean all these other agencies, this alphabet soup of agencies with enforcement and adjudicatory power, can't they come back to us and start seeking injunctions on a deferential standard where agencies win at a much easier rate than can obtain injunctions much more easily than litigants can, and that would vastly expand federal administrative power in a during a time where the Supreme Court is more skeptical of federal administrative power. So it would have, I think, quite wide-ranging and shocking effects if that were to occur, which is partly why I think it will not occur.
Got it. A last question, barring any others from our audience. You've mentioned, okay, NLRB seems like it's going to fail on this one. Do you have a read, even a general or unsolidified one, of how the justices will break out on the issue and what the determinative points will be?
Yeah, it's harder to kind of pick that way, but I think Justice Jackson was, again, the only one. I may have missed something, but I think she was the only one that really said anything in favor of the NLRB's position. This idea that maybe what the district court judge is supposed to be doing is trying to predict what the board is ultimately going to do at the end. None of the other justices seem to support that, and the fact that she said that doesn't mean she's going to rule for the NLRB either. It just could be she's teasing out a position that she finds interesting or wants an answer on. So it very well could be a 9-0. Even Justice Sotomayor pushed back on Starbucks' points on how irreparable harm should be assessed, because it's irreparable harm on an agency's enforcement power. So that might be, what does that mean? How do you irreparably harm an agency's enforcement power? So it's possible, she might write separately to discuss that particular issue, but even she said it's supposed to be the judge that makes the call, not the agency. And so I think she was, if if I had to bet, I would be inclined to think she wouldn't favor the agency on allow the agency to sort of dictate what the judge is supposed to rule. And all the other justices who really spoke about this, their questioning indicated kind of deep skepticism at a differential standard.
Got it. Thank you. That was all incredibly helpful and useful in thinking through the case. We can wrap a tad early and give people a section of their afternoons back. Really appreciate you joining us today,
Thank
Mr.
you.
Lee. Thanks for this section of your day and sharing your expertise with us. Thank you also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.